So as you're getting your food, I'm Katie Hoffman. I'm the scheduler for this group. And it was very interesting last week. Someone came to me after the meeting and was underneath the impression that we were a specific Democratic Party, that we had an agenda each time and we had the voting members and all this kind of stuff. I said, no, that's not who we are. We came together after the 2016 election to find solace in each other, and we formed a really strong group of people that no matter where I go, I see them. We've become a really strong group of folks that's very well respected. In fact, we were reached out to by the Sherrod Brown campaign to be a sponsor of the reception he's going to have with Kamala Harris on October 6th. So it's really cool. It's really cool. We're getting the respect. But once again, we're more social. We don't endorse anybody. We don't have those agendas. And I know in the beginning, people wanted us to do that, but that's not who we are. So, just so you know that. Next week, we will have Brian Gary. He will be here, and he will be bringing several homeless folks with him, so that you understand from firsthand experience what it's like to be homeless in Cincinnati, what it's like to deal with Judge Ruhlman, what it's like to deal with Dieters, and what they have been through over the past couple months. And Brian Gary he's been a warrior for them. He's been with them all the time. So they will be here, so you are going to be seeing the face of the homeless here in Cincinnati. I have an announcement from the Jill Schiller campaign. They are going to be filming her commercial today at 3:30 at Steve Drehouse's house, which is in Finneytown at 990 Timber Trail. They need extras, so to speak. They need normal people. You're not normal, but that's all right. So if you choose to be there, just make sure it starts at 3:30. That you're there at 3:30, but that doesn't mean I've been in these commercials before and it lasts a really long time. So they do take after take after take after take. So it's not an hour and done. So it does take time. But if you choose to go, nothing that says Democratic Party, nobody that says anything, just bland clothing that does not identify you as Schiller or anything else. Yes, John?
Will there be liquid refreshments?
In my experience, no. So I would say pack a lunch. Bring something. So just wanted to let you know, if you're interested in doing that, 3:30 at Steve Drehouse's house, 990 Timber Trail. I've got the information. I mean, Peter won't have time to get that out, in the newsletter between now and then. But I heard from Andy Brown at the headquarters, and he would love to have anybody show up that can show up. Okay, I'm going to turn this over to Alberta Helmsley, who is our founder.
Hello. Welcome again to Tuesday. Thank you. We have a lot going on today. There are 4 people who are going to be running for the Court of Appeals. B, B, C, and Z. One of them we know is Ginger Bock. Yay! We have her today. Who's the other B? Bergeron. And the C is? Krause. And the Z is? Zayas. I want my people from this group are going to know who the 4 people for the Democratic Party are going to be for the Court of Appeals. So we hope you guys come and show up. There we go. Okay. Thanking people here. You just met Katie. My brother. Everybody knows my brother with the bad t-shirts. He loves the TED t-shirts. There he goes. Read his t-shirts every week. He makes sure he's got there. In the back, we have our special person here. Let's see. Bonnie sewing pussy hats. Are you doing pussy hats today? Okay. Bonnie's there with pussy hats. Let's see.
Big scout.
Oh, David Hughes. Where's David? David's there. He says he's still working on Keep
Order Wild, just move on.
Move on. Has anything happened with that?
Nothing, that's the best news.
Good. Okay, we're fine with that. Okay, I've had great meals at the Dree House home and then the Pepper home for Cordray and Denson. We've had really good food. It's really expensive. I didn't put in the 18 cents, but I'll have to owe the Cordray campaign 18 cents. I did get spaghetti on this t-shirt, and I was saying that I wore this to the spaghetti dinner, and that was really fine. My brother's spaghetti sauce was absolutely fabulous, I have to tell you. Very well done. Now, and people didn't mind, I told you I was going to bring this giant chocolate cake, and they didn't have it at Costco. So I got the cheesecake and a large pumpkin pie, which didn't last the meal, which was very nice. I thought that was good. I don't cook, but I do go to Costco. There you go. We need announcements. Peter.
If anyone is not getting the newsletter and would like to, please fill out one of these cards with your full name and your email address. MailChimp does seem to periodically just bump people out of sheer perversity, but don't give up. I keep putting it back, and eventually you should get the newsletters.
I now get 2, it's really good. Other announcements? Pass it on.
Hi, I'm Barbara Myers. I have 2 announcements. The first is for the Cincinnati Women's Political Caucus and Cincinnati Now. We have an open meeting on Tuesday, October 2nd at the First Unitarian Church on Linton and Reading, which is called Win or Lose, What Comes Next. And we're having Jamie Miracle, who's Deputy Director of NARAL Pro-Choice Ohio, and Lauren Blauvelt Copeland, who's the campaign director for Planned Parenthood Advocates of Ohio. And they're going to talk about the lame duck session that's coming up right after this election. And win or lose, there are a whole bunch of restrictions being talked about, 3 different abortion bans, all kinds of legislation that they're trying to pass whether we elect a new administration or not. And so we need to know what's coming and what we can do about it so we can keep fighting even after the election. I have some flyers here if anybody is interested. We'd love a good crowd for this. It's free, there'll be refreshments, and it's always a good discussion. And then the other one is more of a save the date. It's a long-term proposition, but every year the Women's City Club of Greater Cincinnati has a national speaker in, usually always a woman who has done some wonderful things. This year our 2019 national speaker is Helen Thorpe, who is an award-winning journalist who lives in Denver. She has written 3 books, the most recent of which, The Newcomers, Finding Refuge, Friendship, and Hope in an American Classroom, follows the lives of 22 teenagers from literally around the world over the course of one school year as they land in Denver. And it follows particularly 3 families, refugees all, from Iraq, Burma, and the Democratic Republic of Congo. So it's really very of the moment because it talks about why people are refugees and what it's like to try to integrate into America. So that's going to take place on April 3rd, and it's going to be at Memorial Hall. And there'll be a lot more coming, but I'd love for people to put this as a save the date. Thank you.
Maybe for my birthday, I got it.
I'm sorry.
The first announcement.
The first announcement is Thursday, October 2nd. Tuesday, October 2nd, 7 p.m. at the First Unitarian Church, which is on the corner of Reading and Linton.
And what's the event again?
The event is called Win or Lose, What Comes Next. And it's the Women's Political Caucus. and Cincinnati Now. We're teaming up for this event. And I do have some flyers for anyone who's interested on the table. Who is the next announcement?
October 2nd is next Tuesday,
I know.
Are there any people,
2 Tuesdays.
I'm interested in issue 1. I wonder if there's anyone, if we're going to have a program about it, or if there's anyone in here who knows a lot about it, because I'm noticing the Chief Justice O'Connor and Judge Dieters have had things in the paper against it. And I'm just curious about learning more about it. I'm for it, but so anybody that knows more about it, maybe I could talk to you afterwards, or maybe we could have a speaker about it.
Well, Brian Gary is one of the proponents of it. If he's going to be here next week, he
Right.
can talk about it very strongly.
So we have a speaker on that coming next week.
Okay.
We're on it, we're on it.
Just for your information, I've been doing a lot of door-to-door canvassing. I think last week I must have hit over 100 doors. I've been finding something unique. I have seen a lot of elderly, and I'm saying that's anywhere 60 to 90, that I go to their doors, and I am canvassing with the AFL-CIO. So I see union members. It tells me whether they're Republican, Democrat, or unregistered as either. It also gives me their voting history. And so I am seeing a tremendous amount of folks in that age group that have been dropped. And so I had a lengthy conversation with one lady who was a retired teacher, a real strong union person when she was teaching. And she assured me, after we went in, that she has voted every time. She has voted every time, however, she was dropped. And I asked her how she voted. Well, I voted absentee.
There you go.
That is a huge issue if all of a sudden absentee ballots are going missing, are not making it to the elections headquarters. And it is that large group of senior citizens that are doing the absentee ballots. So as you're doing your door-to-door canvassing, get people to check their voter registration, regardless of whether they think they have voted all these times. But they're being dropped, and people don't even know they're being dropped.
There you go.
And they only have 3 weeks left.
That's right, 3 weeks left.
October 9th, I think, is the last one.
October 9th is the last day. I'm getting people who are saying, I've already voted, and I'm thinking, no, you haven't. The ballots are not out yet. You could not have, they're thinking because they sent in something for an absentee ballot that they have voted.
But if they got that, if they got the letter from Houston with the application for it, then they are registered.
But if they didn't get that letter, then they're probably not registered. So if you did not get a letter, please check on your registration to see.
I just stopped by the Schiller office yesterday and found out the Ohio Democratic Party is sending out a huge mass mailing this week about getting people registered and absentee ballots. So the Ohio Democratic Party is going to get it to everybody, regardless of whether Houston, got them that or not. So we do know that that is happening, which is a good thing, but we still have to be very proactive when we are going door to door.
I wore my special canvassing outfit today. Just want you to know I didn't dress up. This is how I go out and greet my neighbors in my Edgemont Springfield L place. And I've shown you my special thing where I have Ginger Bock's name on my place for people to vote for Ginger. Okay. Any more announcements? Announcements. Okay, with that.
Monica's here.
Monica?
Don't forget, you've got those $10 signs that probably mean more now than any time at all.
The what?
I'm your neighbor.
Did you get the mic?
Get your microphone.
No idea what you said. no idea about the signs. Those wonderful signs. Turn it on. Ah, there we go. Oh, sign. Right there, no matter where you're from, I'm glad you're my neighbor. I was contacted by someone just out of the blue who needed 100 for a Labor Day picnic and bought me out. And so I ordered some new ones in Spanish again. And so if you would like one, let me know. I'm putting in an order for those as well.
We have about 5 back
We have 5 back here in Nepalese and Arabic.
All right. Just right here.
Okay. Any other announcements? Ginger, I think we're there. And without further ado, for today, we have Ginger Bock, who is for the Court of Appeals, one of our 4 Court of Appeals people.
Thank you, everybody, for coming. One of the issues with judicial races is that there is a very large drop-off between the top of the ticket and the judicial races. Part of it is that people don't know the judicial candidates, and trust me, we are trying to change that this year by getting out.
I'll switch it back.
There's dues at this table. $10 to sit.
Is that working?
Yeah.
Okay.
We're loading my car.
Part of the issue is that people don't know who the candidates are, so we're really trying to get out as many as possible, meet as many people as possible. I spent the weekend canvassing door to door, and I've had so many people comment that, wow, you're actually doing this yourself? And my answer is yeah. You know, I go to where the people are. And then the other problem is that people don't understand why the courts are important. They don't understand why it's important to vote for state court judges. And so today I am talking, I have a baker's dozen of cases that I'm talking about that will affect people more so than what you would think. So normally when people think about the courts, they generally think about the criminal courts. But there's a whole civil division as well. And you know, it touches divorces, it touches custody cases, personal injury cases. And there's a very wide variety of cases that courts touch. Pretty much anything that you can imagine will end up at the First District Court of Appeals, because the First District Court of Appeals does not decide what cases they take. They take appeals from all of the lower courts. So if it's in court and trial court, the First District Court of Appeals will take it. So I am running for the First District Court of Appeals. I'm one of 4 Democratic candidates running. And before I start going through this list, I just want to mention 2 things quickly. First of all, there's a event tonight at Lydia's in Clifton. The slate is going to be there. We're going to speak. You can talk to us. You can learn more about each of us. Also, for those of you who are beer drinkers, as you can see, I have the perfect beer name. You've heard of Amber Bocks? Well, guess what? Now there's going to be a Ginger Bock. I have somebody brewing one for me as we speak. October 3rd at 5:30 at the Anchor OTR will be the unveiling of the first that I know of Ginger Bock beer. It's called The Candidate, and we're hoping to be able to change the name to The Honorable. So, all right, now I'm going to start my cases. There are sheets on, like, spread around the tables. I don't think there's enough for everybody that lists the names of the cases, and I will start. So the first one is Cincinnati Enquirer versus Giz. So this case was the Tensing case, where Officer Tensing killed Samuel Du Bois on UC's campus. He was charged with murder and manslaughter. So this involved 2 different appeals. Not of the criminal case itself, but this was a First Amendment case, freedom of the press. So the press sought the juror questionnaires, and Judge Giz put out orders saying that the press could not have the juror questionnaires, and also severely limited media access to the courtroom. They immediately appealed that to the First District. The First District sent it back saying, you didn't have a hearing, these orders are automatically improper because you have to have a hearing if you want to close the courts. The second orders, she made a second set of orders, and she had some testimony. She had hearing, there was testimony that some of the jurors filled out their forms, they expressed discomfort at being identified, and Judge Giz,
gave judicial notice, and that's basically when a judge says, I as a judge can establish this as a fact. There was a different criminal trial, and the defendant's friends had used social media to locate the jurors. And she also gave judicial notice that certain interactions between police officers and African-American citizens where deadly force was used or death otherwise resulted have found their way into criminal courtrooms, and some judicial outcomes have led to massive public outcry and even serious violence against persons, but she need not list or detail these incidents. So, her orders, she denied the release of the juror questionnaires until after the trial and only with a lot of redactions, and she also severely limited media access. She only allowed a random 4 media outlets into the courtroom, and she allowed for 1 camera that had a feed going into a media room, and she also even limited the people who were allowed on the 5th floor, which is where her courtroom is. The justification was that there was a lot of attention, and she didn't want to intimidate the jurors, so that was basically her justification. So, naturally, the media appealed, and they sought, there were 2 different writs that they sought, and I don't want to go into a lot of detail about what these mean, but a writ of mandamus basically is the petitioner is asking the higher court to force the lower court to do something. In this case, they were asking the court to release these juror questionnaires. And so the Ohio Constitution guarantees open courts. So if you want to go to court, you're allowed to go. Courts generally are not closed. The only way that they are closed is if there's a really high interest in having them closed, and if the order is very narrowly tailored to fit that interest. So in this case, the juror voir dire is also part of the open courts, including the written questionnaires. So what the first district said is that Giz did not individually question the jurors, and her evidence was not enough to overcome the presumption. So the juror questionnaires, the media was entitled to the juror questionnaires with redactions. They weren't allowed to have personal information about the jurors. They weren't allowed to know the names or the employers or the addresses, but they were allowed to see what they put on their juror questionnaires. So that was the first part. The second part, the writ of prohibition, it's asking the trial court, asking the higher court to make the lower court prohibit the trial court from excluding the media. And in this case, they punted. They said, the trial's already over, so this is moot, we're not going to decide on it, it's not likely to happen again. Judge Zayas dissented to that part of it. She said that the courts cannot rule on moot issues, however, and that's a general concept, a court cannot rule on a moot issue. However, there's an exception when there's a case that evades review but is likely to come up again. And that's why they ruled on the questionnaires. But as far as the media attention, the court said that that's not likely to happen again. Judge Zayas said, yes, it is likely to happen again. Every single media outlet in Cincinnati sued for the open court, and it's going to happen again. So the bottom line here, the next time a case like this generates a lot of media attention, the trial court can do this again. And according to this decision, there's really nothing they can do about it. So that's one. And by the way, for the most part, I'm really trying not to pass judgment on these decisions, and I know that I do sometimes, but I'm trying not to.
Why?
Because I'm not a sitting judge yet. That's why.
And when you are, you
Well, as a candidate, what else we want to know, what you think?
But it's talking about.
Since this is already, I can't talk about the case, I can't talk about the portion of it that might appear again. Simply because with issues that might appear before the court, it is unethical for a candidate to talk about how they would rule on a case. There's, the canons say that judicial candidates and judges have to be independent and have to judge things solely on the case that appears. So I can't really talk about something that might appear before the court. Yes?
Could you just briefly let us know, right now, the makeup of the Court of Appeals?
Yes.
In terms of party and stuff?
Yeah, sure. So there are 6 judges on the Court of Appeals, the First District Court of Appeals. Judge Zayas is the lone Democrat, the other 5 are Republicans. Pardon me? Judge Zayas is the lone Democrat, yes.
Marilyn, you helped elect her last time.
And yes, in 2016, she was elected. It was considered to be an upset, and she is running to defend her seat this year. All right, so moving on. Community Press versus the City of Blue Ash. So in this case, the City of Blue Ash hired a consultant to perform employee reviews of senior management. This was basically the employees' peers and their employees did reviews, and then the consultant compiled the information into a report and gave it strictly to the employee. Didn't go in the personnel files, didn't go to their bosses, it only went into their personnel files. So the Community Press learned about the assessments, it submitted a public records request, and the Blue Ash refused to hand them over, and the Community Press sued. The trial court said that Blue Ash had to provide the records because the records were public records under Ohio's sunshine laws. So basically, Ohio sunshine laws say government records generally are public records, but there are tons of different exceptions. And the way public records are defined is that it's any document created or received by any public office that documents the organization, functions, policies, decisions, procedures, operations, or other activities of the office. In this case, the Court of Appeals reversed. It found that these records were not public records because it didn't document the city's organization, functions, policies, etc. Because the records went directly to the person and only to the person rather than a personnel file, they consider these not to be public records. Bottom line here, a public employee can have a performance review, and if it just goes to the employee rather than personnel files, the public does not have access to it. Okay, next case. So, yeah, that was the appeal. The Court of Appeals reversed the trial court. No, if it went to the Supreme Court, I don't have it on here. I will talk about one Supreme Court case, but we'll get to that in a few minutes. Speaking of, I'm actually glad you brought that up. And you're an attorney, so you know this. The Supreme Court only accepts somewhere between 5 and 10% of cases that are brought to it. And it's a court of limited jurisdiction. For most cases, it doesn't have to accept them. For most cases, the first district is the court of last resort in Hamilton County. Okay, moving on to, everybody's heard about civil forfeiture lately. That's been a big topic. And that's where the government basically takes money or other assets that they think are from a crime, like the proceeds from a crime or used in the commission of a crime. So in this case, in re $18,823. Police searched Holly Galvez's residence. It was in connection with a drug trafficking investigation, and they seized computers. They seized about $2,000 in cash. They seized marijuana and a Xanax, for which, by the way, she had a prescription. And they also seized money, more than $16,000 from 4 different bank accounts. She was charged with a 4th-degree misdemeanor for the marijuana, and she pleaded guilty to a minor misdemeanor, and that's kind of like the equivalent of a traffic ticket, basically. So the state sought to civilly forfeit the money that they had seized from her. At a hearing, the officers testified that Galvez was the girlfriend of a known drug dealer. He gave her money, which she admitted. Her income that she reported to the IRS was significantly less than what she said that she was earning from her job and putting in the bank herself. When asked directly, though, the officer said that he couldn't specifically say whether any of the money in these bank accounts was seized, that they had seized was the proceed from a drug transaction. So Galvez testified that her boyfriend did pay her $1,300 a month for rent, but otherwise she denied receiving any money from him or putting money in the bank for him. She was an exotic dancer. She made a lot of cash, and she said that she would deposit that into her bank account. So the Court of Appeals said that the state has to prove that the funds are the actual, the trial court found that they could seize it. The Court of Appeals said that the state has to prove that the funds were the actual proceeds of drug trafficking in order to get forfeiture. And the state has the burden to prove by preponderance of the evidence, so that means basically that much. Just 51, just a little bit more. So a preponderance of the evidence that the money seized was from a crime, basically the proceeds of a crime. And for most of the money, the state could not prove that the money was related to trafficking, and the court said that her underreporting her income for the IRS had absolutely no impact on this case. That did not help the state prove that the money was proceeds from a crime. There's no Supreme Court case at this point ruling whether legitimate money got from your job, may be seized when it's commingled with other funds. But the First District Court of Appeals ruled that it has to be specific. If it's commingled, it doesn't matter. Unless you can specifically trace the money as the proceed of a crime or used in the commission of a crime, it can't be seized. Yes?
Haven't there been cases, because I've read about some, where people had funds seized that turned out to have nothing to do with the crime, and the police still didn't want to return it, and they had to go through all kinds of court cases in order to get that money back. So it applies more than just to somebody who's arrested because they have some drugs in their house.
Yes.
These were people going on vacation who had a lot of cash with them, and for whatever reason, they got searched, they seized the money, and then they never got it back because even though there was no crime at all, the state said it was a legitimate forfeiture, which is ridiculous. That could happen to any of us.
There was a John Oliver episode, and if you don't watch John Oliver, you should. Frankly, I love him. I would probably leave my husband for him.
Okay.
But don't tell him I said that. I'm not recording that statement. But anyway, but John Oliver had a show on civil forfeiture, and it was fascinating, absolutely fascinating and infuriating. So if you haven't watched it, do. It was incredible.
So that's an important ruling.
It's very important, absolutely important. So the police have the burden to show that the money was a proceed from a crime or used in the commission of a crime. If you would like. Okay, so the next one, Donopoulos versus American Trading 2 LLC. So a thief stole Irene Donopoulos' jewelry from her house, and one of the accomplices sold it to a pawnbroker over on the west side in Cheviot. It was American Trading Company. The pawnbroker disassembled the pieces, resold it for more than 3 times what it had paid for it. The sheriff learned that American Trading had purchased and then sold the stolen jewelry. Irene asked for it back. American Trading refused, and so she sued them for conversion. And what conversion is, it's a civil tort. It's withholding property from an owner's possession under a claim inconsistent with the owner's rights. So it's kind of like civil theft. So there were 2 appeals in this case. In the first case, and I'm actually really glad Tom walked in on this because I'm going to mention his opponent in a second here. So the first appeal, it was a summary judgment in favor of the pawnbroker. What a summary judgment is there's no trial. It's the person is denied trial. So basically, the judge decides, looking at the facts and at the law, that no reasonable person could find in favor, in this case, of Irene. Because the pawnbroker had complied with a state statute that governed pawnbrokers, it was vested with ownership rights in the stolen jewelry, and its ownership rights, according to the summary judgment, were superior to Irene's rights, the rightful owner. The first appeal, Court of Appeals reversed, and it said that the statute did not modify the common law rule. The thief did not acquire title to the property, so therefore Irene's rights were superior. Sent it back for a second, sent it back, and this time it was in front of Judge Hartman. So Judge Hartman, yes. It was a bench trial. So a defendant can forego a jury trial and just have the judge listen to the case and basically the judge and the jury. In this case, Judge Hartman was the judge and the jury in the case. He was the fact finder. And he rendered a verdict for the pawnbroker. What he said is that it disassembled and sold Irene's jewelry without her consent. However, Irene had the duty to demand her own jewelry back from the pawnbroker before they sold it. And so keep listening. It got reversed. The Court of Appeals reversed the case. And it found that American Trading had converted these pieces. Wrongful purpose isn't necessary. Even if the pawnbroker did not know that it was buying stolen property, its rights to the jewelry were still inferior to Irene's rights to the jewelry because she was the rightful owner. So it had, because it had taken the jewelry, intentionally dissembled it, and then sold it, its rights were not higher than hers. So Judge Hartman got reversed.
Yay! So how do they stay in business if they have to have each and every piece coming in the door? Not something like that. Could we use the microphone?
What question did she ask?
I'm going to repeat it. She asked, how do they stay in business if they have to know that every piece was not obtained by theft? I don't have an answer for that. I mean, the case is what it is, and I don't know their business practices, so I don't have an answer for that one. Okay.
Here, Tom.
Well, do you have a reasonable presumption for stolen property?
Microphone.
Yeah, because we had this as a prosecutor. I'm not going to jump on Ginger, but do you have a reasonable presumption to know that it is or is not stolen when you obtain it as a pawnbroker? And if the prosecutor can show that there was reasonableness, that they should have known it was stolen, that negates their rights. Even though they have the right, though, once someone asserts a claim, and that's what the Supreme Court was saying, they then have the duty to return it.
So this is the difference here, is this is a civil case.
Oh, it was civil?
Yes.
Oh, it wasn't
criminal?
criminal?
No, it was civil conversion.
Oh, okay.
Yes.
Oh, God, yeah.
Never mind.
Yeah.
Never mind. You're late, sorry.
Okay, so the next case is Walton versus Royal. This was a judgment entry rather than a full decision. Let me just throw that in there. So Cedrina Walton was at her friend's house, who was a tenant. She was severely injured by her two dogs that attacked Walton. The tenant was a tenant of Thomas Gibson, who was the homeowner, and Walton sued both the tenant and Gibson. Gibson died in the course of the litigation, which really isn't important to what I'm saying, but just keep in mind that the facts that were found were from what his family said rather than from what he testified, which I think makes this a little bit more interesting. But so in the lease agreement, the landlord, Mr. Gibson, prohibited dogs from being on the property. But he had seen that she had dogs, but he denied knowing that they were vicious or that they had attacked anybody in the past. The trial court granted Gibson summary judgment, and the Court of Appeal affirmed that summary judgment. So there were two claims here. The first one was negligence. The plaintiff, Walton, she failed to show that Gibson knew that the dogs were vicious, and the knowledge was essential to the negligence claim. So that's one. The second part, with dog attacks, there can be strict liability, but the plaintiff has to show that a person is the owner, possessor, or harborer of a dog. And the issue here, I mean, he wasn't the owner, he wasn't the possessor, so it was whether he was a harborer of a dog. So a harborer is one who has possession and control of the premises where the dogs live, and they acquiesce to the dog's presence. In this case, the Court of Appeal said that because he leased the premises to somebody else, she had taken over the control and possession of the premises, so he no longer had that. So he was not a harborer of it. Now, what in this case, the bottom line, what happens here, whether it was decided correctly or not, the bottom line here is that a homeowner almost always has insurance. A renter doesn't. So if somebody is attacked by dogs or hurts themselves on a renter's property, oftentimes their injuries are not going to be compensable. And if somebody is a renter, you know, when somebody sues somebody, usually they go after their insurance company because the person doesn't have the means to pay themselves. But they still do go after the person. So my point is here, get insurance, because it's really important. All right, next case, Stanfield versus Reading Board of Education. A student participated in Reading High School's track and field program and the discus event. In the practice area, the netting was gaped and there were big holes in it. The practice area was actually owned by the city of Reading. The netting was owned by the Reading Board of Education. A student suffered a severe head injury because a discus hit him in the head. He sued both the city of Reading and the Board of Education. The appeal involved only the Board of Education. So the Board of Education moved for summary judgment. The trial court granted summary judgment, finding that the board was immune under the political subdivision immunity statute. So basically, it's very often litigated, actually. It's a very often litigated issue. Generally, political subdivisions are immune from tort claims. The tort claim is basically you're injured by something that somebody else does. There are tons of exceptions to this. It's very complex, but one exception is if an injury is caused by a physical defect on the grounds or in a building used in connection with the performance of a governmental function, then there's not necessarily going to be immunity. So the appellate court actually reversed here. The board had argued that the student was injured on the city's property, so the board couldn't be liable. But the court held that the physical defect exception applied because the board's employees chose to use netting with holes, and they were stored in a shed on Redding's property. So, and nobody disputed that it was a governmental function, so therefore, because the board made that choice, the exception applied. So the bottom line here, political subdivision immunity is very often litigated because it's very complex, and there are often disagreements about what the statute means and whether something is a governmental function or whether it's one of the, any of the exceptions exist. Tom actually could probably talk about that a lot more than I could because he works for the city, but yes.
Sovereign immunity and children on.
Can't hear you.
Sovereign immunity and children on property. I mean, that was below 18, wasn't it, the business servant? I mean, that's what.
I believe he was, the court, what she asked is sovereign immunity and children on property. The court did not discuss the issue at all, so for whatever reason, it wasn't germane to their analysis. Okay.
I don't understand who won that case.
The plaintiff didn't necessarily win the case, but the plaintiff got to take the case to trial. They found that the board could be held liable for the injury because it happened on government property and there was a defect, and the defect was of the board's own doing.
And the judge ruled against the Mr. Stanfield.
The trial court did, and the Court of Appeals reversed, yes.
Are you allowed to say who the judge was?
I don't know who the judge was. I wrote it down if it was somebody who's running this year.
Go Ginger.
All right, this next one is an older case. It's a Supreme Court case. In a minute, you're going to find out why I chose this case because you'll see. All right, so it's TW versus DL. It's a 2002 Supreme Court case. So what's that?
12.
2012, what did I say?
2.
Oh, 2012, yeah, Supreme Court case. So LL, when he was born, his parents gave him the first name, and then he had 2 middle names, which was the dad's first and last name, and then his surname was his mother's surname. The parents agreed, they both signed the birth certificate. So, the little boy lived with his mom and his sister, and they all had the surname L. So when the little boy was about 4 years old, the couple split. And the father sued for paternity, and also for visitation. And they agreed on everything. They agreed on custody, they agreed on child support, they agreed on everything, except at the hearing, the dad decided that he wanted to change this little boy's name from the mom's name to his own name. The little boy was still living with his mom and his sister, who all had the same last name. So at the hearing on this, the dad testified basically that it was really important to him that the little boy have his last name. He wanted him to carry on his legacy, and it was just really, really important to him. The mom, on the other hand, testified that her little boy, first of all, had some significant developmental delays. He was 5 and had just almost learned how to spell his 4-letter last name. He also had some mental health issues that made him particularly sensitive to change, and she was very concerned that changing his name would be a huge setback for him. She was, very, very upset about it and did not want this to happen because she was concerned about the little boy. So the magistrate found in favor of the dad. The trial court adopted that decision, but wrote its own decision. And it used some language. For example, it said that if the mom got married, it was likely that she was going to change her name, and it was less likely that the dad was going to change his name. And it was it emphasized the father-son relationship over the mother-son relationship, and agreed with the magistrate. She appealed it to the 12th district, and the 12th district affirmed. And that is when she came to me. So that's why I'm talking about this one. She came to me and said that she wanted to appeal it to the Supreme Court. And I took the case, and when you have Supreme Court cases, the first thing you need to do is ask the court for jurisdiction. And like I said, somewhere between 5 and 10% of cases are accepted for jurisdiction. The court accepted it 4-3. All the women voted for it, the men voted against it. And then, so the court accepted it, and the court ended up unanimously siding with the mother. It found that the father had not given any evidence really at all that this would be in the child's best interest, and that's the key. The person who is trying to change the name has to show that it is in the child's best interest, and the father's testimony was really about his own interest rather than the little boy's. So the court sided with my client, and all is good. I actually was in contact with her a couple of weeks ago, and the little boy is doing great. He's about, let me think, that was 8 years ago, so he's about 12 now, and yeah.
Question?
Yes.
Yeah, I just wanted to say that I hope the court found that instructive, that when they ruled on whether to accept the case, it was 4-3 along gender lines, but when they ruled on the case, it was unanimous. So at least 3 people learned something.
You know what's interesting? I actually had a conversation with one of the justices about 6 months later after she had left the court. And the person who authored the decision walked into the conference room after 100% against me. And the women convinced him to go the other way. Okay, moving on to what is it?
Obasagate.
Yeah, there we go, Obasagate. Obasagate versus Obasagate. This was a divorce case. The parents disagreed on child custody and child support. The husband proceeded pro se, which means he did not have an attorney. The trial court awarded the mom custody, and the dad appealed. On appeal, the dad argued, one of his arguments was that because he was unrepresented, the trial court should have given him more leeway. The Court of Appeals stated a long-standing rule: pro se litigants are held to the same standard as other litigants and are presumed to know the law and the correct procedure. And this has been a long-standing rule, it's nothing new, but I just bring that up just to share the point that if you or somebody you know represents themselves in court, you are under the exact same rules as a practicing attorney. That's one of the reasons I think it's so important that people give to legal aid and other organizations that help represent people who can't otherwise afford it. Yes.
Are you in favor of what people would call like a civil Gideon statute?
I'm not sure what that is.
The ABA's had for maybe 8 years that would provide a right to counsel, paid, compensated right to counsel.
For all civil cases?
For certain civil cases, social welfare, life custody cases.
I would have to read the language before I could give an opinion on that. But initially, it sounds like it would be something that...
expensive, so...
Right. I would have to read the language of it before I could comment on that. But that's interesting. Okay, so next, City of Blue Ash versus Price. I'm going to go through this quickly because I see that I'm running out of time. So Matthew Price was cited for riding a motorized skateboard in a crosswalk. He violated Blue Ash's toy vehicle ordinance, which prohibited people from using toy vehicles like skateboards and whatever on public roads or in public parking lots in Blue Ash. Mr. Price appealed his citation to the municipal court, and the court ruled that Price was not guilty. But more than that, it ruled that the ordinance was void for vagueness and violated a person's constitutional right of movement. So Blue Ash appealed the unconstitutionality. The state cannot appeal somebody's guilty conviction, or not, I'm sorry, not guilty finding, but they can appeal certain aspects, like in this case, the constitutionality of the statute. So, Court of Appeals reversed, found that the statute was constitutional. Ohio recognizes the right to freely travel public roads, but the right is not implicated by restrictions on the mode of transportation. For example, vehicles have to be registered. You're not allowed to wear earbuds when you're driving. So it's okay to restrict the mode, but not the actual movement. And the vagueness, they found that this was not vague, and like I said, I wasn't planning on saying whether I agree, but I totally agree with this one because it actually used the word skateboard in the statute. So, bottom line here, statutes and ordinances have to be clear enough for people to understand what it is that they're not allowed to do.
Okay, mate.
Yes.
Yeah.
Wait. There you go.
Am I to understand that the child, was it a child?
It didn't say.
Okay, that the individual was using the skateboard in crossing the street,
Yes.
not on the street itself,
Yes.
but in a pedestrian walkway which is accessible to him under any circumstances.
Except when you're using a toy vehicle.
Except when you're using a toy vehicle. I'll take off my roller skate.
Okay, the next case is Rural Building of Cincinnati versus Evendale, and I'm going to go through this one pretty quickly. So this is about the takings clause. And by the way, this was a judgment entry. This was not a full decision. Generally, when the government takes property from a private citizen, they have to compensate them for that property. There are exceptions, and I'm going to talk about one of those right now. So the Rural Building of Cincinnati, RBOC, owned a building in Evendale, and it was zoned general industrial. They entered into a lease with the United States government for an ICE facility, including detention holding center. The zoning board denied a certificate of approval because of the detention center in it. The zoning board of appeals affirmed that decision, and RBOC ended up, after that, it sold the property, and then it sued for a regulatory taking, claiming that the denial of the zoning certificate caused it to lose the ICE lease and the profits. The trial court found that there was no taking. The Court of Appeals affirmed. There's no black line rule about how much loss of income or loss of use is considered a compensable taking. If there's not a physical invasion of the property, in other words, if it's not eminent domain, or if there's not a total deprivation of economical use, then you must consider whether the economic impact of the regulation on the property owner, you have to balance these things, the economic impact on the owner, the extent of the interference, and the character of the government action. And to be a taking, the reduction in the economic value has to be extreme. Here, it was no more than 40%. It didn't give an exact number, but they said no more than 40%. The board's decision didn't actually stop this company from bringing in income. It made significant income from previous leases, so it found that it wasn't a taking. So bottom line here, this was around a 40% taking, and it still wasn't considered a compensable taking. There's one more quick case, if you wouldn't mind, that I go through.
We got one more before Mr. Beridon.
Okay, so this one actually was a 12th, I'm skipping a couple, but I just found this one interesting. So it's a 12th district case. Michael Berkheimer was eating boneless wings at a restaurant in Butler County. He ingested a bone, and he suffered some severe injuries. It was lodged in his throat, he had a severe infection, and he had some permanent injuries from this. So the trial court actually dismissed the case on the pleadings. It found that no discovery, just simply on the complaint. It found that as a matter of law, bones are a natural part of the chicken, so he should have been on guard, and the term boneless is irrelevant because everybody knows that bones are in chicken. So in the past, courts have used two tests. There's the foreign natural test, which if a bone is naturally in a type of meat, it isn't a foreign substance and the consumer has to be on guard. The other test is a reasonable expectation test, which is should the consumer reasonably expect to find bones in their food? So there was a prior Supreme Court case on this that rejected the foreign natural case, but basically said that whether bones are found naturally in a food is a big factor, but it's not the only factor. In this case, the 12th District reversed the grant of summary judgment because there has to be a case-specific inquiry. They have to look at how big the bone is. They have to look at, the process for deboning the meat. They have to look at the advertising. So in this case, the court dismissed and sent it back to the trial court. However, it did make the comment that usually these types of cases are dismissed on summary judgment. That means that the plaintiff doesn't get a trial. So bottom line here, if it says boneless, watch out for bones.
Or go vegetarian.
Think about. All right, Tom, did you want to talk?
This sweater was left here last week, if anybody.
Don't get it boneless.
Okay.
But you get
I can't follow that. That was incredible. I mean, how many times have you had a candidate come in and explain the law to you and go over specific cases that deal with your everyday life? Shows you how much judges impact us and how much it affects our lives. So, one more time. My name's Thomas Beridon, and I've been here before. I think I've spoken to most of you. I'm running for the Court of Common Pleas. The reason why it's so important to have judges is that we have people who have different life experiences. I know Ginger went over her background. We actually met each other back in 2001 when I was running David Crowley's first city council campaign. Ginger came in and did our database for us. So we have two very long-term Dems who are very committed to the ideals of the Democratic Party. As judges, we'll hear each case individually, but it's important to know that you have people that you can talk to and understand your values and are willing to come out and talk to you about your life and your cases and how it affects you. I know we're short on time. The one thing I'd really like to bring up today, and someone told us on right back there, is that, as you remember, there are no D and R's next to our name. I know you'll all remember to vote for us when you go to the ballot, but your neighbors may not, your friends may not. So it's very important to take a yard sign so you can put in your yard so your friends know that you support Ginger and me and the rest of the slate. Also, like us on social media so it gets out there and they know who we are. It's very important. This is the first primary ever where Democratic judges got more votes than their Republican counterparts.
Yeah.
We can keep that up. We've had more voters register for early voting who identify as Democrats than we have before. It's quite possible we will have more voters out this year than we did in 2008. But it is very important that everyone vote all the way down the ballot. In fact, I've heard some people say start from the bottom and work your way up. I'm fine with that because I'm probably going to be the last judge on the ballot because I have an unexpired term. And when people go to the ballot, we should have people there handing out the sample ballot. Hopefully all of you will volunteer on election day to do that. But every little bit of media counts. Yard signs are very important for that. Social media is very important for that. Thank you so much for coming out today. Appreciate your time.
Thank you, Tom.
We need it for all the judges. Thank you.
One more case, actually. There's time for one more case.
There's one more, time for one more case?
Yeah.
Can I say something before? Remember the very first case you talked about, Giz, the whole thing with Sam DeBose? She is running for office in the open race against Pavan. And so it's very important. Pavan and Erica Underwood are endorsed by the ex-CIO, that much I can say. And so it's really important that what they do in court and how they kept the media out, etc., affects us all. And so that was Leslie Giz.
One more minute.
We want to know the one last case.
Well, I'd just like to say that because of this name recognition issue, if you have limited space for yard signs, I think yard signs for judges are more important than any other issue.
Thank you. Okay, so in Ray VB, parents of this child were not married. The couple split up. The father sought sole custody at first. There were several versions of an unsigned parenting agreement. Neither party filed a motion or pleading for a shared parenting agreement. So the guardian ad litem filed a written report. She recommended shared parenting, and she also expressed a concern about the mom excluding the dad from major decisions in the child's life. The magistrate wrote his or her decision, basically finding that she or he was without authority to consider shared parenting because the parents had not filed a motion or a pleading seeking shared parenting. Gave full custody to the mom with only visitation to the dad. The dad objected, the trial court adopted the decision, so the Court of Appeals affirmed. So custody matters are based on statute. The common law will interpret the statute, but the statutes are very rigid. Since neither party here filed a pleading or a motion asking for shared parenting, the court had zero authority to do that. So as far, bottom line here, if there's a couple that isn't married and is trying to work out custody, and if they want shared parenting, they have to follow the procedure, or else the court doesn't have any authority whatsoever to grant shared parenting. So that's the custody issue. Yes?
Can we go back to the first case about Tenzin and Giz?
Sure.
I don't follow, how'd that turn out? Was she overruled?
In part. In part.
Did the inquirer win?
In part. So what happened, the trial was already over by the time that the court listened to this case. But what the court found is that juror questionnaires are presumptively open. So if a judge does not individually question the jurors, then the juror questionnaires are open to the public. They can be redacted, so they're not personally identified by name or whatever, but juror questionnaires are presumptively open to the public. The part that they ruled against the inquirer was that they punted on the media restrictions. So they didn't rule on that at all, finding that it was a moot issue. And Judge Zayas, like I said, dissented and said this is going to come up again and again and again. Because every single media, not every single, but most of the media outlets in Cincinnati sued in this case, and there was no decision made on that.
You may not want to answer this question, but I've always thought that Dieter set it up so that they couldn't convict Tenzin because they went for murder instead of manslaughter. You may not want to answer that.
I believe so.
How do you agree?
And it's okay to punt.
I'm going to have to punt on that one.
But you're probably right.
I
can say that.
You was not charged with
Yes.
manslaughter.
Is there a tendency for appellate judges to side with the same party of the original judge?
What I'm going to say is that 85% of the judges here in Hamilton County are Republicans. In the trial court, there are only 3 Democrat judges. In the Court of Appeals, there's 1. So Pierre did a review of 200 cases from either 2016 or 2017, I don't remember which. 3% of cases were totally reversed. All of the others were either affirmed or affirmed in part. Draw your own conclusions. Yes?
To what extent is it possible for people to determine what judge they get?
None.
None whatsoever?
None. Well,
There are finaglings that go on, aren't there?
Well, there's one that we just been talking about a lot lately, is equity judge. So
Yes.
there's an equity judge who, if there is, and the exact term Ginger probably knows better than I do, is if there is a danger of imminent harm or irreparable financial harm, you can request that it be fast-tracked to the judge who is the equity judge that month. When I first started at the city, I was told about this system, like, okay, great, this is a problem, we have to file an injunction to get this from going forward. I will file and we'll see who we get as equity judge. And they said, no, just call and see who it is this month. I'm like, what? It's the 31st, there's no way they're gonna tell me who the equity judge is next month, then I might wait till next month. Oh no, they'll tell you. So I called them up, who's the equity judge next month? They told me, I said, well, who's the judge after that? I said, so-and-so. They have it all listed out through the year. So economic harm can be justified at any time. The city has one suit right now where they waited 2 weeks to file an injunction on a new law that had passed until it changed equity judges. And in their brief, they stated, well, the law passed 2 weeks ago, it suddenly became an economic hardship to have it. So one of the things that Terry's brought up, and I agree with this wholeheartedly, is that we need to go to a system that makes it a secret equity judge. So you do not know who the next month equity judge is, so you can't plan your filings. I'd love to say it's horrible and I've never done it, but I have. When you're working on behalf of your client and you're within a couple days, there's no harm in waiting a couple of days if you think the other judge will be more beneficial. The problem with that, though, is it creates an unfair footing to people, and we shouldn't have that option at all. So if me and Terry are elected, and Pavan as well, we've talked about going into the panel, because that's a discussion that has to be made with the entire judges to have that removed. And we go more like Cuyahoga County and Montgomery County that keep it secret until that month. Thank you. Sorry, we
Oh
just
my
talked about
goodness.
so much last night.
Here we have judges. These are judges who should be elected.
Yes, they are.
Go for it. Thank you, Bock and Thomas Beridon. Thank you so much for coming. You guys have done it again. You've done wonderful questions. You have great answers. You have any more questions and answers. And thank you for coming. Finish the food. One more thing.
If anybody wants my outline, let me know and I'll email it to you. Ginger for Judge, actually you can email my work, which is gbock@morelaw.com, MOORE law.com. If you want my outline, I'm happy to send that to you.
You have a bunch of your cards right here.
Yes, yes I do.
There you go.
And if anybody wants a copy of my 2 flyers, they're right here.
Great. Barbara Myers has flyers for you on those two
Of those 2 events.
events that she has.
One for next year, one for 2 weeks.
There's a handout.
Okay, thank you for coming, folks. Thank you so much for being here.